We now move on to the inchoate offense of attempt. Now, attempt can be quite tricky, right? So look at this example. When does an attempt begin? D decides to rob a petrol station, buys a balaclava and some gloves, borrows his grandfather pistol, borrows a car, parks outside the petrol station, enters the petrol station, walks towards the cashier, gets the gun out of his pocket, points the gun at the cashier, and demands the money. When can he be said to have committed the offense of attempted theft or attempted robbery? Because here he has not obtained the money yet, so there's no appropriation, right? So therefore there's no theft. But can he be said to have committed attempted theft or attempted robbery? At what point do you think that the attempt begins? Well, hopefully by the end of the lecture on this part, you'll be able to figure it out. Now, attempts is found under the Criminal Attempts Act 1981, specifically at Section 1(1). And it provides as follows: if with intent to commit an offense to which this section applies, a person does an act which is more than merely preparatory to the commission of the offense, he is guilty of attempting to commit the offense. So it's pretty straightforward, right? The actus reus is to do an act which is more than merely preparatory to the commission of the offense. If it's just preparing to commit the offense, it cannot be attempt. So it must be more than merely preparatory. That means he must have basically started to commit the offense, except that he has not completed the offense yet. And the mensura is that he must do so with the intention to commit an offense, right? With the intention to commit an offense. Let's look a bit in the history, right? This was the Pre-Criminal Attempts Act 1981. How did common law actually determine when an attempt has been committed? Well, an attempt has been attempted. Now, in the case of Eagleton, they used the last act test, right? So what was done before the last act, which actually meant that the crime was committed. So what was the last act that was done just before the crime was committed? Then if the last act was committed, then it would consider to be, well, you have attempted to commit the offense. In Stonehouse, the question that was asked was whether has the defendant crossed the Rubicon and burned his boats. Now, what's this about the Rubicon, right? For some of you may know what the Rubicon is. The Rubicon is actually a river in Italy, right? A river in Italy. So this is Italy, and the Rubicon is actually there. And in the past, Rubicon actually separated the northern kingdom from the southern kingdom, right? Back in the days of the past, rivers are usually used to mark boundaries. And if the thing about it was that when you cross the Rubicon, basically you are crossing over you're crossing the boundary and entering to the territory of the other side. And by doing so, well, we all study public international law, right? You are actually infringing in the sovereignty of the other kingdom, and it is basically a declaration of war. And this was depicted, right, when Julius Caesar crossed the Rubicon. And when he crossed the Rubicon, he basically said that the die is cast. Basically meaning that that's it. War has been declared. There's no turning back. So when you say that you cross the Rubicon and burn your boats, it means that you have passed the point of no return, right? You've passed the point of no return. That means you cannot turn back already. Not really very helpful though. If you think about it, doesn't really help us to understand. So we look at the post-Criminal Attempts Act cases. And the first case that we're going to look at is the case of Gulliver. And in Gulliver, it was held that attempt begins when the merely preparatory acts come to an end and the defendant embarks upon the crime proper. Okay, when the merely preparatory acts come to an end. So it doesn't really say much because the Criminal Attempts Act says that it's more than merely preparatory. So obviously the merely preparatory acts must come to an end. It gives us a bit more by saying that it is when the defendant embarks upon the crime proper. So what this will be will depend, of course, upon the facts in any particular case, and it's not easy to determine sometimes. Okay, when is it that the defendant is still preparing to commit the offense? Right? When is he still preparing to commit the offense? So we look at the facts of the case of Gulliver. In this case, the defendant went for went to place a bet for a greyhound race. Right? When place a bet on the greyhound race, it's like horse racing, except they use these greyhounds instead. And he noticed that the hound that he placed his bet on was obviously not going to win, put it this way. He was obviously not going to win, and that means that he was going to lose his money. So therefore, what he did was that he jumped onto the greyhound race track, and distracted the dogs, right? Distracted the hounds, so that the race will be called off. Okay, so that the race will be called off, and he succeeded in doing that. Since the race was called off, then he was hoping that they would refund them all the money that they placed on the bets. He was charged for attempted theft, though, and so the question then is that has he done acts which are more than merely preparatory for the commission of theft? And the court said that no, he wasn't even in a position to actually appropriate the money. All he did was that he actually caused the race to be disrupted. So that was still preparing. That was at the preparatory stage in order for him to be able to go and get his money back. Well, to get the money that he has placed the bet, right? So the court concluded that clearly it was just merely preparatory acts. So we need to be able to identify what is the offense that's being committed or he was attempting to commit, and see whether was he still preparing to commit the offense or has he embarked on the crime proper already. Another case is the case of Campbell. And here, the case of Campbell, also the court echoed what was stated in Gulliver, is where the defendant embarks on the crime proper. So in this case, the defendant was trying to rob a post office. He went in there at first, and then later he came out again. And subsequently, he was going to go in again, but he was arrested just before he entered the post office. Now, they found on him things which indicated that he was clearly going to rob the post office. But the question was that can he be charged for attempting to commit the robbery of the post office? Because he was actually outside. He hasn't even entered the post office yet. So the court said that he cannot be said to have embarked on the crime proper, right? He wasn't even in the post office in the first place. He was still preparing to go and commit the offense. Now, cases also, there are some other cases like Getz and Tosti, which may not be very helpful also to help us to fully grasp when is a person considered to have committed merely preparatory acts. But looking at the facts of these cases, you may be able to get a better idea. Like in the case of Getz, he was actually found in the toilet of a school, right? Toilet of a school. I mean, he was an adult. What was he doing in the toilet of a school? They found him hiding in the toilet, and he had with him a backpack. And in the backpack, he had a knife, he had string, and he had this tape with him. Now, clearly, what he was doing was that what he was planning to do was he was going to abduct a child. Right, he was going to abduct a child. He was just waiting in the washroom for the child to enter into the washroom. So the question then is that can he be said to have committed he hasn't committed the offense yet. Can he be said to have attempted to commit the offense? And the court said that no, he was still preparing to commit the offense. Right, he was still in the preparatory stage. He placed himself in the toilet with all these things to prepare himself to commit the offense. There was no child inside there. There was no children inside there, so he could not have embarked on the crime proper yet. He was still preparing himself. Okay, but in the case of Tosti, this was a bit controversial because in the case of Tosti was when he was trying to break into a barn, and the barn was locked, and here he was examining the lock, right? He was examining the lock, and that was when he was caught and he was charged for attempted burglary. And it was said that he was clearly past the preparatory stage. He was embarking on the crime proper. So that's it for the actus reus for attempt. You must show that he was doing acts which are more than merely preparatory, and the mens rea, as mentioned just now, that he must have intended, right? He must have intended the crime. If it was a conduct crime, then he must have intended the action that constituted the actus reus of the offense. If it was a result crime, a crime where there was a consequences, he must have intended the consequences. Okay, so for example, if it's murder, he must have intended death. So having the intention to cause grievous body harm is not enough. He must have intended the consequences of the offense, which was murder. And this was decided in the case of Walker and Hales. This was a case where they beat up the victim and actually threw him off a 3-story building. So the question, but he survived. The victim survived. So the question was that what was their intention? Was it the intention to kill, or was it the intention to cause serious injury? Because since the victim did not die, they cannot be charged for murder, but they could possibly be charged for attempted murder if the intention was to kill. Now, if there was an offense which have circumstances in it, right, it must be shown that the defendant must possess the intention or knowledge which was required as to the circumstance of the offense. Now, example would be attempted rape. Now, bear in mind that this is attempted rape under the old law, 1990, where the defendant must know or be reckless as to the lack of consent. Okay, he must know or be reckless as to the circumstances of the case. Okay, coming back again to Tony Stark in Endgame. Can you attempt to commit an offense which is impossible to commit in the first place? Same question as we talk about conspiracy. Can you attempt to kill somebody who was already dead? Or can you attempt to steal, right, this infinity gauntlet? Because we know that it is just a work of fiction, right? It's not real. There's no real infinity gauntlet. Or perhaps let's make it easier, right? Can you be said to attempt to steal all the gold that I have in my house, all these gold bars which are in my house, which is impossible because I don't have any gold bars in my house, right? So when you try to break into my house to steal the gold bars, which doesn't exist, can you be said to have attempted to steal the gold bars? Well, the statute provides that yes, you can, just like conspiracy. So Section 1(2) of the Criminal Attempts Act, the defendant may be guilty of attempting to commit offense even though the facts are such that the commission is impossible. He can still be guilty of attempting to commit the offense. Section 1(3) even goes on to say that even if the offense is impossible, the defendant will be liable if the facts which were as he believed him to be was possible. What does this mean? Well, let's look at the cases, right? In the case of Anderton and Ryan, this was a case where the accused bought a video player, something which you may not know what it is. Basically, it's like a DVD player or a Blu-ray player, right? But in those days, it's a video player. It plays video tapes instead of DVDs or Blu-rays. And okay, before you go to Shifuri, right? So let's go back to the video player first. Yeah. So the accused here thought that the video player was actually stolen before he bought it, right? Before she bought it, rather. So she was charged for actually receiving stolen goods, but since that it was found that the video player was not stolen, was not in fact stolen, right? She was charged instead for attempting to receive stolen goods. Now, attempting to receive stolen goods. Now, the argument was that how can she have attempted to commit the offense when it was impossible to commit since that the video player was not a stolen good? There's no way that she could have committed the offense of receiving stolen goods. So the court actually agreed and said that therefore she cannot be found guilty of attempting to receive stolen goods because it was impossible for her to commit that offense in the first place. Now, don't you think that this actually goes against Section 1.2 or even Section 1.3 of the Criminal Attempts Act? Yes, it clearly goes against that. So you can see that in Shipuri, the House of Lords in 1987, Anderton and Ryan was a House of Lords decision also. So the House of Lords very quickly reversed the decision. Of course, they couldn't overturn the decision Anderton and Ryan, but in Shipuri, the House of Lords said that the Anderton and Ryan was decided wrongly. Okay, Anderton and Ryan was decided wrongly because in Shipuri, the attempt was to actually deal with drugs. What the accused were trying to do is that they were trying to deal and handle drugs. However, when these drugs were tested, right, it was found that it was not drugs, it was just a harmless vegetable powder. So these accused were clearly cheated or tricked. And the question then was that can they be considered to have attempted to commit the offense? So again, the issue arises that it was impossible for them to attempt since that the drugs were not there in the first place. It was not drugs at all. But in the case of Shipuri, the court House of Lords said that following the Criminal Attempts Act, sections 1, 2, section 1, 2, and section 1, 3. Sorry, let's go back to that part. Apologies for this. Let's go back again. Section 1, 2, and 1, 3. Even if it was impossible, he will be liable. If it were possible, if the facts were as he believed it to be. So if they look at the facts as if as what it would be if it was what they believe it to be, and they believe that this to be drugs, and therefore it would have been possible for them to commit the offense. So yes, it can be guilty of attempting to commit an offense, even though it may be impossible for you to commit that offense in the first place. So that's basically it for attempts. Okay. The actus reus is that it must be a more than merely preparatory acts is when the accused embarks on the crime proper, and for the mens rea is that there must be intention. Now, just a couple of things to point out before we end on attempts. Is it possible to attempt to conspire? Section 1.4 provides that no, you cannot attempt to conspire. And also Section 1.4 says that you cannot attempt to aid and abet. Okay, so that brings us to the end of the English law on inchoate offences.